Let's see how much we can accomplish in the next
11 or so minutes. Hey, and while we're here, if you could subscribe, that would be so awesome, and it doesn't cost you anything, so thank you for your support.
Let's dive in. Contracts. Contracts will cover about 12% of your licensing exam. The elements of a valid contract in California are legally competent parties capable of contracting, mutual consent, also known as offer and acceptance, legal purpose, sufficient consideration. Legally competent parties are those who have the legal and mental capacity to enter into a contract. Contracts entered into with legally incompetent parties are voidable at the option of the incompetent party, but may be enforced against the competent party. Minors may enter into contracts, but the contract isn't enforceable by the other party to the contract.
So for example, you're an adult and you hire Chuck, the 14-year-old kid who's your neighbor's son, from across the street to mow your lawn every week for $20. If Chuck forgets or gets busy or just never does it, you can't enforce this contract. It's voidable because they're an incompetent party. However, if Chuck mows your lawn and you don't pay him the $20, he can enforce the contract, even if verbal, against you. You're a competent party. You agreed to give him $20. So don't be cheap and pay Chuck. He mowed your lawn. Another example, let's say Chuck proved he was trustworthy. He's been mowing your lawn. You've been paying him $20. This is great. Let's say you hire him to watch your beloved dog, Muffin. If Chuck forgets, well, you can't enforce that contract against him. He's 14. However, again, if he watches Muffin and takes care of Muffin, you have to pay him because you're a competent party. You agreed to that. Make sense? Great.
California law prohibits minors under 18 from entering into any contract related to real estate. For example, a minor cannot buy or convey real property, and a real estate licensee can't represent a minor in a real estate purchase or sale. These limits do not apply to emancipated minors. Parties who may enter into a contract include emancipated minors, aliens, individual proprietors, partnerships, LLCs, corporations, nonprofit associations, personal representatives, and convicts. Mutual consent, also known as offer and acceptance, occurs when the parties enter into an agreement voluntarily with a full understanding of contract terms. The contract must be voluntary. Mistakes, misrepresentation, fraud, duress, or undue influence create a situation in which the consent is not real. A signature is the party's confirmation of understanding and intention regarding the terms of the contract, but a valid contract can be made without signatures, as in a verbal contract. However, signatures make the contract more easily enforced in court. Legal purpose means that the contract results in a legal outcome. A contract written for an illegal purpose is void. Consideration. Consideration is something of value given in exchange for another thing of value. For example, the buyer gives the seller money in exchange for the seller's transfer of marketable title to the buyer through delivery of a deed. Valuable consideration is usually something of economic value, though it can be an action or a promise to not act. Although not deemed valuable consideration, a gift is deemed good consideration and meets the required element of consideration in a valid contract. Earnest money in a real estate contract isn't consideration and isn't a required element for a valid contract. Contracts may be valid but unenforceable. For example, a voidable contract is valid but may not be enforceable in a court of law. Contracts signed under the following circumstances are unenforceable. The contract is for an illegal purpose. One or more of the contract parties were under duress or undue influence. One or more of the contract parties committed misrepresentation. The contract terms are patently unfair or violate public policy. The contract contains errors. The Statute of Frauds requires that certain types of contracts, such as for a property ownership transfer, be in writing to be legally enforceable and to prevent injury from fraudulent conduct. A contract that doesn't comply with the Statute of Frauds can still be valid, but it's unenforceable. The Statute of Frauds also requires written contracts to identify the contracting parties, identify the subject matter of the contract, present the essential terms and conditions of the contract. A voidable contract is one that appears valid, but one or both parties have a legal right to disaffirm it. This could be because one of the parties lacks legal competence, or because there was a mistake or misrepresentation, causing a failure of reality in consent. The contract is voidable by the incompetent or misled party, but enforceable against the other party. A void contract isn't a contract at all, because it lacks one or more of the requirements for a valid contract. It also has no legal force or effect. It's unenforceable. In contractual language, performance means meeting the terms of the contract. The parties should operate in good faith to execute the contract with no deceptive practices. All parties must comply with contract terms in a timely manner. Time is of the essence. An executed contract is one in which all parties to a contract have met all contract terms. A contract for the sale of real estate is executed by the delivery and acceptance of the deed and the payment of the purchase price. Notice that you can also see the terms executed used to refer a document that's been signed. Contracts are executory until all of the promises in the contracts have been completed. A contract for the sale of real estate is executory until the deed is delivered and accepted. Breach of contract occurs when one party fails to meet contract obligations. The innocent party may take any one of several actions as a remedy to the breached contract. Partial performance is when one party meets some but not all of the terms of the contract. The innocent party may agree to accept partial performance, perhaps in return for some sort of compensation. The innocent party can sue for damages. This is a means of seeking monetary compensation to make up for any harm caused. A specific performance suit seeks to force a party to make good on the promises made in some way, usually by requiring the breaching party to perform the original contract terms. Many real estate contracts include a liquidated damages clause that limits buyer damages to a return of the earnest money if the seller breaches the contract. Contract discharge, aka performance or execution, means that the parties have met all contract terms and are discharged from their contractual obligations. When one party to a contract agrees in writing that the other party is no longer held to the provisions of the agreement, this is called release. Contract rescission, cancellation, generally results from an operation of law, such as breach of contract, destruction of the object of the contract, etc. If the contract is rescinded, it is terminated, and the parties are legally returned to their position before there was a contract. For example, if one party breaches the agreement, the other may legally have the right to rescind the agreement. This is known as unilateral rescission. Parties to the contract may terminate the contract through mutual agreement. This is best accomplished through mutual written release. Assignment means to transfer contractual rights or duties to a new party. Some contracts have provisions either permitting or prohibiting assignment. The phrase "and/or assigns" after a party's name in the contract makes the contract assignable. Unless the parties agree that the original buyer or tenant is to be released from contract obligations, the original party remains liable if the new party fails to meet the contract's obligations. Novation occurs when one contract is substituted for another. The agreement may be between the same parties, or a new party may be substituted. This is novation of the parties. The intent between the parties is to discharge the old obligation, releasing the original party from those obligations. Insertions to pre-printed forms are interpreted in a specific order of priority. Typed insertions take priority over pre-printed material, and handwritten insertions take priority over typed and pre-printed material. Numbers written out alphabetically prevail over numerals. State laws govern the use of electronic documents and signatures. The Uniform Electronic Transactions Act, UETA, UETA, is an attempt to bring some degree of standardization to state laws regarding the use of electronic documents and signatures. It gives electronic signatures, records, and contracts the same legal weight as paper records with wet signatures, signed by hand in ink. The UETA defines an electronic signature as an electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign. Electronic documents and signatures can only be used if the parties to the contract agree. In a bilateral contract, both parties have obligations. Most real estate contracts are bilateral. For example, a purchase contract contains promises by both parties, so it's bilateral. In a unilateral contract, only one party makes a promise, like I promise to pick you up from the airport. An option contract is one example of a unilateral real estate contract.
And that's it for now. Stay tuned for part 2. Thanks for coming along. Please like and subscribe. Thank you so much. Bye.